days on the off chance that I get to see you.
Hey, she wins. No. Your name, ma'am? Thank you. All right, what are we doing?
You can feel the courtroom energy settling into that classic pre-hearing tension where nobody quite knows whether this is going to stay procedural or suddenly turn serious. Judge Simpson is moving quickly, but underneath that casual rhythm, there's already a major issue forming: bond. And bond hearings are never just about paperwork. They're about trust. Can the court trust this defendant to come back? Can the court trust the promises being made by defense counsel? And maybe most importantly, can the court trust that the community stays protected while the case moves forward? What makes these hearings fascinating is that both sides are technically arguing about the future using only the past. The defense is about to paint a picture of stability, support, and second chances. Meanwhile, the prosecution is preparing to stack financial issues, prior cases, and credibility concerns into one giant warning sign. And once those competing narratives collide, Judge Simpson has to decide whether this defendant walks out the door or stays behind bars. And here's the question for everybody watching. If someone has unresolved warrants and unpaid obligations, should they still get another opportunity before trial, or does that history already answer the court's question for them?
Our attorneys never requesting money on and for the negotiations.
Gotcha. Probable cause conference, April 24th, 2025, 9 a.m. Bond continued.
Can I just volume?
Yeah, go ahead.
You said I was winning, so.
Yeah, but that could change real fast. Go ahead.
Your Honor, Ms. Moses has no prior assault criminal history. She is not a flight risk. She doesn't have a stable home to live in Jackson with her mother. We also will provide her transportation to make further court proceedings. We are asking for a PR bond in this matter. We have no objection to any testing or any other conditions imposed by this court, including the GPS tether.
Response.
Your Honor, the defendant currently has 2 holds out of Kent County. One for OWI, she was convicted of in 2023, or OWBI, excuse me, where I understand she still owes money on, and another for a child support warrant. The defendant also does have assault criminal history. She was not convicted, but she was charged last year with a domestic violence case that was ultimately dismissed. Furthermore, in this case, the defendant is alleged to have stolen packages and has sent, or is alleged to have sent, a letter admitting to and apologizing for the same to the victim in the case. There is an offer that has been extended to allow her to plead to a misdemeanor for days restitution up front. But I told defense counsel, given the fact that she has a warrant for not paying child support, she has a warrant for not paying her fines and costs on the OWI in Kent County, she has a residence in Jackson County and is here in Washtenaw County where she was previously living, stealing these packages. I am not convinced that she would come back to court, nor am I convinced that if she were to get out of custody, the victim would ever see the restitution in this matter if it's not paid up front. So I am requesting the court continue the bond as currently set, finding it to be appropriate.
But how's she going to even have a shot at trying to get restitution if she's incarcerated?
That right there is the moment the hearing shifts from a routine prosecution versus defense argument into a practical reality check from Judge Simpson. The prosecution is emphasizing risk, unpaid obligations, prior legal issues, and concerns about compliance. But the judge cuts directly to the core contradiction. If the defendant stays locked up, how exactly is she supposed to earn money, pay restitution, secure employment, or resolve any of these? Financial problems? This is where courtroom logic gets complicated. On one side, the state is arguing that the defendant's history suggests she won't follow through. On the other side, the defense is essentially saying, you can't expect progress from someone sitting in jail. And honestly, that tension shows up in courts every single day across the country. Judges constantly balance accountability against practicality. Notice something else too. The defense immediately pivots towards structure and support. Transportation from family, employment plans, tax refund money, stable housing with her mother. Those details are not random. Every single one is being used to build credibility brick by brick because credibility is currency during bond hearings. And Judge Simpson is clearly listening closely here. He's not just reacting emotionally, he's testing whether the defense story actually holds together under pressure.
And defense counsel told me this morning that her mother will be helping her make those arrangements and that she is going to be using her tax monies.
And Your Honor, if I may, you make a very valid point, which I would like to emphasize. My client does need to get out of jail to secure employment and to start paying off all those fines and costs that she needs to pay off. And federal tax day is coming up next week. So on April 15th, so if she's here and can't pay that off, that adds to it. And Ms. Moses did make clear to me that she does plan on securing employment and her mother will be taking her to the court proceedings moving forward.
Where would she reside if she were out in Jackson?
Jackson.
So all of her holds are financial holds,
Yes, ma'am.
right?
I do believe that the child support is a child support case related to.
I'm going to modify the defendant's bond, grant the defendant's motion. I'm going to modify it to a $10,000 personal recognizance bond. Defendant must be placed on a GPS location only tether prior to her release.
And good morning, Your Honor. Robert Allen, on behalf of Fitzgerald in case 5072. We need.
Okay, where's my second ruling? Oh, no, saunter up. We'll wait.
Now we transition into an entirely different type of courtroom problem. And this one is dangerous for defendants because it involves alleged bond violations tied to substance use. These hearings can unravel extremely fast once testing results enter the conversation because judges tend to view failed compliance as a direct challenge to the authority of the court itself. And pay attention to Judge Simpson's demeanor here. He slows the room down immediately. That usually signals that the judge understands the next discussion could materially affect someone's freedom status. Defense counsel is about to ask for more time, more discovery, and more context regarding the violation report, but the court clearly wants specifics, not vague explanations. What also makes this hearing rough for the defense is timing. Timing matters enormously in drug testing disputes. Once prosecutors start lining up arraignment dates, testing dates, reporting dates, and prior conditions from other jurisdictions, the courtroom conversation becomes less about excuses and more about timelines. And timelines are hard to argue against because judges love objective sequences of events. This is the kind of hearing where one bad answer can completely destroy judicial confidence within minutes.
Assistant Public Defender, Tamara Care, I can really on behalf of Mr. Fitzgerald.
Your Honor, I want to start by thanking you for passing this case earlier and allowing us this time.
All right. Have you seen the community corrections violation report?
Yes, we have, Your Honor.
You're doing on this today?
Your Honor, as far as my case itself, I'm asking for an adjournment. I was disappointed yesterday, and there will be time to obtain discovery. You'd like us to address the violation, we can go right into that.
Go ahead.
So, Your Honor, the test on April 2nd was my client's first test. He also has a case out of Livonia that he actually tested for yesterday and tested clean. He says that he will test clean today.
Do you have those results?
We do not, Your Honor. I didn't have an opportunity to call Livonia. It's on-site substance abuse testing here in Washtenaw County. We can absolutely reach out to them. He states that he did not sign a release of information, but it seems like he was confused, Your Honor, because of his testing obligations in the Livonia matter. He didn't realize that he would have to be simultaneously testing. I told him that he could sign a release.
How long's he been testing in Livonia?
That was my second week.
What was your second week?
Yesterday. Yes, second test.
What do you have as his appointment date?
And here comes the problem the defense absolutely did not want formally stated on the record. The court now starts walking through the testing timeline piece by piece, and once Judge Simpson hears that the defendant allegedly tested positive for fentanyl, cocaine, opiates, and amphetamines, the entire hearing changes tone instantly. Notice how the judge focuses not only on the positive result itself, but also on the number of substances involved. That matters because, from the court's perspective, this no longer looks like an isolated misunderstanding or technical violation. It starts looking like a broader compliance issue. Then things get even worse once the discussion shifts toward another active case in Livonia with separate conditions already in place. That's a massive credibility problem. Courts tend to be much more forgiving when defendants acknowledge mistakes early and demonstrate immediate corrective action. But when multiple jurisdictions, multiple conditions, and multiple alleged violations begin overlapping, judges start asking a much harsher question. Why should I believe the defendant will follow my order if they're already struggling to follow someone else's? And honestly, you can feel Judge Simpson becoming increasingly skeptical in real time.
Yeah.
Well, I have his arraignment date as March 31st. I have a test on April 2nd with a report on April 9th that he's positive. He was instructed at the time of arraignment he's not supposed to be using drugs. He's positive for fentanyl, cocaine, opiates, and amphetamines.
Your Honor,
Also, as I'm to understand that at the time he tests positive for these, he's also not supposed to be using narcotics from his order out of Livonia. So you'll be in violation in that case also. Go ahead, you wanted to say, Mr. Allen.
well, Your Honor, I think when his arraignment on the 31st, I do know, and I'm not a scientist, but we know that sometimes it takes some time for drugs to get through the human body and out of the system. And as I said,
Is he going to tell me that that he did not use after the 31st?
he says he did not use after the 31st. Again, that test, the positive test was on the 2nd.
When did he test in Livonia before that?
This exchange is incredibly important because Judge Simpson is no longer debating theory. He's now trying to reconstruct a precise timeline. And once judges begin cross-checking dates this aggressively, it usually means they suspect the explanation being offered doesn't fully add up. The defense is trying to introduce reasonable doubt about when the substances entered the defendant's system. They're essentially arguing that the positive test could potentially reflect earlier use rather than a new violation after arraignment. But the prosecution and the court are looking at the overlap between arrest dates, arraignment dates, plea appearances, and testing obligations across jurisdictions. And that's where defendants get trapped. Even if there's uncertainty around exact timing, courts often focus on overall compliance behavior. Were you proactively testing? Were you transparent? Were you following every condition strictly once released? Judge Simpson also makes it clear that context matters. A single disputed result might create room for debate, but layered concerns combined with multiple substances create a much steeper uphill battle. Let me ask you this. If a defendant claims they stopped using immediately after arraignment, but the testing timeline still raises doubts, should the court give them the benefit of the doubt or prioritize caution and public safety first?
I can tell you the exact date, but around the same time. It's the exact
Your Honor, if it helps to establish the timeline, Mr. Fitzgerald would have been arraigned on his OWI out of Livonia on February 4th of 2025. He then, his next appearance in that case was when he entered the plea on April 1st. I'm assuming that he was transferred there after being arrested on this matter, which obviously occurred the day or two prior to that. And controlled substance possession is obviously one of the charges here.
So what makes me think if he was in violation of Livonia's orders that he's not going to be in violation of mine? Because he is in violation of mine. This one.
Your Honor, all I can ask is that you give him a chance to show you that he can follow your rule.
And I'd like to add also that if we can, I don't know what the conditions for his Livonia case would be, especially now that he has entered a plea. But I know that here, obviously, we've got outpatient treatment, we've got CCOP, we've got some inpatient options. Clearly, substance abuse is an issue at this point. He says that he has been trying his best. He reports that he would be clean today. We don't have the results from the other test yesterday, but hopefully those are also negative for any substances, Judge. So we ask that he might at least have the opportunity to get an evaluation or assessment to see if we can get him for a treatment program.
Anything else you want to say?
No, Your Honor, just that you give him a chance. Like I said, he's been, like co-counsel has said.
Well, let's do this. You can get a release from him. I want those Livonia results because something's not quite adding up. He's, and it's not like it's one drug. He's got a whole cocktail in him when he comes here to testify or comes here to test. So I'll adjourn his probable cause conference to next week, the 17th, 2025 at 9 a.m. And I'll just say this. I also am not believing, given the basically shelf life of some of the drugs in his system, that he didn't use after I am not convinced that he didn't use after he was arraigned. So at this time, defendant's bond is revoked, and you guys can get a release of information from him and make a determination as to getting those test results to me, and I'll take another look at it.
And this is where Judge Simpson finally lands the plane. After hearing the timeline disputes, the arguments about testing confusion, and the requests for another opportunity, the court ultimately decides that the inconsistencies are too significant to ignore. The judge openly states he does not believe the defendant stopped using after arraignment, and that statement is devastating because credibility is everything in bond matters. Once judicial confidence disappears, bond revocation becomes far more likely. Judge Simpson does leave a narrow path open by allowing additional testing information from the Livonia matter to be gathered and reviewed later, but for now, the ruling is clear. The defendant's bond is revoked. The court wants more verified evidence before considering another release decision. That's a major reminder that bond conditions are not suggestions, they are direct court orders, and violations can immediately change the trajectory of a case. Across both hearings today, we saw two completely different judicial outcomes. One defendant received a modified personal recognizance bond with GPS tether conditions after arguments about financial hardship and stability. The other lost bond privileges entirely after serious concerns involving drug testing, compliance, and credibility. And that contrast tells you everything about how courts evaluate risk. Not just the allegations themselves, but whether the judge believes the defendant will actually follow the rules moving forward. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.